Welcome to PBCJ's coverage of the sitting of the Senate. I'm Simone Absalom, and I'll provide a brief outline of what's expected to take place during the sitting. But before we begin, did you know that the Joint Select Committee of Parliament is often established to review legislation being considered by members of the upper or lower houses of Parliament? On this session's agenda, under public business, debate is to continue on the Trusts Act 2018. The Trust Act seeks to create a modern statutory instrument as it relates to the most pertinent principles of trust law. It began in the House of Representatives on July 10. In the last sitting of the Upper House, Leader of Government Business, Senator Kamina Johnson-Smith, who piloted the bill, pointed out that regulation of the conduct of trustees is governed by the 1897 Trustee Act, which she noted is clearly no longer in sync with today's commercial climate or indeed common law.
The bill seeks to not only update the legislative framework, but it seeks to address the needs of a modern economy in which the investment community has increased its use of the trust as a vehicle to enhance the returns that may be earned from assets that are comprised in the trust or that comprise the trust. The bill includes provisions that will strengthen the regulatory environment and accountability standards to which trustees are to adhere. Further, it seeks to bolster the protective measures for persons who are affected by the terms of a trust or provide services related to trusts, inclusive of trustees.
The legislation addresses the creation, validity, duration, and enforceability of trusts, identifies the property that may be held on trust, and establishes the procedure for the appointment or removal of trustees. In modernizing the law in relation to trusts, the bill is created to codify the common law, repeal the Trustee Act, and provide savings and transitional provisions for continuity, and to preserve the validity and enforceability of trusts created under the Trustee Act. The legislation also includes provisions for the keeping of accounts, impartiality, the giving of information, the separation of trust and property, and the preservation of trust property. The bill also provides for the power to relieve trustees from personal liability and indemnification of trustees by beneficiaries, and for the settlement of actions against trustees by alternative dispute resolution. Also on the agenda, debate is to continue on the Food Storage and Prevention of Infestation Amendment Act 2019. According to the Ministry of Justice, this is an act to make provision for the storage of food and for the prevention of loss of food by infestation and for processes connected therewith. That's what's on the agenda. It should be noted that elements of the day's agenda can be changed or moved. But before we go, here are a few things you should bear in mind if you plan to attend a session at Gordon House. No visitor shall create any act of disorder within the precincts of the House. No visitor shall be admitted to the House without first obtaining an admission card. Visitors who remain within the precincts of the House during a suspension of the session are asked to keep silent. No photography, videography, or sketching of the proceedings is allowed unless so authorized by the presiding officer. And there should be no smoking inside the parliamentary building. Now over to the proceedings.
Proceed, Minister, proceed. It's not that. Anyway, go ahead.
Mr. President, I apologize for any inconvenience. But the Ministry of Foreign Affairs and Foreign Trade has become aware of the matter involving 4 Jamaican fishermen who are bringing a case against the United States Coast Guard for alleged mistreatment following their arrest and detention in 2017 in Haitian waters. The Ministry wishes to advise that it became aware of the matter yesterday, Thursday, June 13th, through social and print media reports. We have also seen a video in which the fishermen concerned cite experiences of shocking treatment during an extended period of detention that would amount to human rights abuse. The allegations are of serious concern to the ministry, as the rights of Jamaicans at home and abroad are always of paramount importance to the government of Jamaica. We note that the American Civil Liberties Union, the ACLU, has agreed to provide the men with legal representation, and that the matter is now before the court of law in the United States. It is hoped that justice will be delivered through that process. We are investigating the situation with our consulate in Miami and other relevant government agencies as we seek to learn more about the case, but to date have not discovered any record of a complaint having been reported to the consulate or headquarters in Kingston. We want to take this opportunity to remind Jamaicans who travel overseas and who experience difficulties. These matters may be reported to the nearest consulate, embassy, or High Commission, or on their return to the headquarters at the ministry in Jamaica. I thank you, Mr. President.
What you could do, Minister, is get a hard copy and circulate in due time.
Having regard to...
Senator Knight?
Thank you, President. Having regard to that which you have already been briefed on, where did this incident commence? And was it, from your information, in breach of any agreement between the United States of America and Jamaica? If so, which agreement? And what steps do you intend, does the government of Jamaica intend to take as between the two states at the diplomatic level?
Mr. President, we are not in possession of any information which would allow us to answer the questions posed by Senator Knight, and would simply note that we continue to inquire about the matter, as I have said, both from government agencies and through our consulates to find out the circumstances. As I indicated, the only issue on which we are clear regarding what you just raised is that the matter took place in Haitian waters. We have no Haitian waters. We have no other information at this point in time other than what has been set out in the case documents. The matter is before the court, and we therefore have to be quite sensitive about how we address those things. So, Mr. President, I have indicated that we are inquiring further to see if there is anything else which we can or should do, but at this point, we are, I can only state the matters which I have set out earlier. Thank you.
Mr. President, so you're going to get
the matter is in court in the United States of America. Whilst I understand your approach of sensitivity, the fact is that quite apart from a legal issue, there is an issue which would arise as between the relationship between states, and that has nothing to do with the legal issue pending in the United States of America.
Sorry, Senator Knight. My impression was that the sensitivity related to the interest of the Jamaicans who have the matter there.
That has no place in this. Nothing about sensitivity can arise to prevent a protest. There is an agreement, the shipwright agreement. Has that been breached?
On a point of order, Mr. President.
Well,
Mr. President, on a point of order.
Senator Knight, just Senator Knight.
Mr. President, on a point of
Senator Knight.
order.
Senator Knight.
Rubbish.
Senator Knight. Senator Knight.
Look here, don't follow people. Don't follow people.
On a
Senator
point
Knight.
of order.
Senator Knight.
Mr. President, the statement by the gentleman makes it seem as if something has been breached. The minister said that we're investigating by the senator. Makes it appear as if there has been an established breach. The statement by the minister said we're investigating.
That's not a point of order.
The question as to whether it's a point of order really rests.
Hold your lane.
The question of whether
Keep in your lane.
Senator Knight. Senator Knight. The question as to whether or not it's a point of order rests with me. Continue, please.
It is incompetence why this is happening now. On your part, Minister. You are an incompetent minister. Something as urgent as this from yesterday morning at least, and you come here, you don't even know. You don't even know. You haven't even looked at the shipwright agreement. It's not a matter of speculating on anything.
Senator Knight, you have a... Senator Knight.
Hold your corners,
Senator Knight. Senator Knight.
Neither are you.
Senator Knight. Senator Knight.
1 second. I want you to...
Senator Knight. Senator Knight.
Let me just be clear.
Senator Knight, the minister has made a statement and you are permitted to ask questions.
Yes,
will you just do that so we can...
I'm going to make something pellucid. When I'm questioning the minister, it would be wise for neophytes to be quiet.
Senator Knight, Senator Knight.
Mr. President, I am certain that there is a standing order that speaks to comments which are abusive to colleague senators.
I have never known
Senator
the
Knight.
word neophyte to be an abusive word.
Mr. President,
Could I ask you just to continue?
Mr. President, I wish to ask that you emphasize to the senator
That what?
that it is his experience in this house gives him no more authority to
No,
pronounce
this
on
is
matters
not a
of Jamaica than myself.
That's not a point
Whether I am
of
new or
order.
not gives him no
President-
authority
President-
to speak with greater residence
President-
than I on matters of the nation.
Senator Morgan, Senator Knight is well aware that every senator has the right to be heard and participate in a debate. Senator Knight, could I ask you please to just deal with the issue at hand? Senator Knight, just deal with the issue at hand.
Well, you know, I usually and will on this occasion ignore rude wimps. President, this matter came to public attention yesterday, and this morning the Minister of Foreign Affairs and Foreign Trade in the Senate is reading from her telephone, her smartphone, to make a statement to the Senate.
And as information.
And after the passage of more than 24 hours, cannot tell the public of Jamaica whether or not the shipwright agreement was relevant and whether it was breached and what steps will Jamaica be taking?
Okay. I understand that to be a question. Minister, can you tell whether or not the shipwright arrangement with the United States has been breached and what steps are being taken?
Mr. President, as I indicated before, we are making inquiries of the matter. The matter is sensitive, and whether Senator Knight may have assessed that in his consideration, the issue does not affect the case, is not a position which the government of Jamaica can take. So we are inquiring about the matter, but the statement stands as it has been put forward. Inquiries are being made of the relevant agencies. I will not speak in a speculative manner in order to assuage someone's, I don't know.
Senator Knight, you have
quite
another
frankly,
question?
I don't understand the phrase, the issue does not affect the case. Don't know what that means. But let me put it this way. It is not likely that any reasonable response will be given because the situation has not been treated with the urgency that it deserves, and where inefficiency reigns, clarity will be absent.
Mr. President.
Senator Knight, thank you. Senator Brown?
Yeah. Mr. President, the event which led to the minister's statement today occurred, as I understand it, in 2017. That's 2 years ago. Can the minister indicate to the Senate when was the first time that this information came to the attention of the government of Jamaica?
The minister indicated that answer, she said that it came to the ministry's attention yesterday, as no report was made to any of the agencies of government.
Mr. President, citizens of Jamaica have been incarcerated in a foreign country. Their consular responsibilities. And I wish to know whether or not the United States government in any way informed the consular service or the government of Jamaica that they were holding 5 Jamaicans in their custody. I wish, Mr. President, to you, the minister, to answer that question.
The minister is whether or not you were informed by any of American governmental agencies that 5 Jamaicans were being held incarcerated.
What I have indicated, we know that the men were deported. They were deported, and therefore we have confirmed that there are records of deportation.
When were they deported?
In 2018. No, that is a matter of record that we have been able to ascertain. Having inquired, because as I stated earlier, there's no record of any complaint of this matter. The Ministry of Foreign Affairs became aware of this matter yesterday by virtue of the media reports. On making inquiries, we were able to confirm that the men were deported in 2018. These names there are records. But the broader issue, we're making inquiries because we do not know enough about this case. So I cannot speak further on it.
President, deportation from a foreign country require contact with the country to which a person is being deported, in this case Jamaica. I wish to know whether or not these deportees were debriefed and whether or not reasons for their deportation was provided to the government of Jamaica in 2018. It can't be that is yesterday we heard about this thing when these people, when government to government contact must have taken place in 2018. Did we do the necessary debriefing of these deportees? No, the government of Jamaica.
Well, no problem, Senator Brown, no problem.
And I have more questions.
Mr. President, the Ministry of Foreign Affairs is responsible for the consular aspect of deportation. It is the Ministry of National Security which is responsible for everything else. I am saying, and I have said, I think, several times this morning, that we, the Ministry of Foreign Affairs, are making inquiries of not only the relevant consulate, which would be the Consulate General in Miami, but also of the relevant government agencies and departments. I have stated that several times, and it will unfortunately be the response, it appears, to all the other questions as well.
It's clear, Mr. President, that the government of Jamaica knew about these events from 2018. It's clear that the government of Jamaica...
Senator Brown, Senator Brown,
Yeah?
Senator Brown, you're asking us a question, and I don't really want to get involved in it, but you said the government was aware from 2018. Where is that evidence? The minister says yesterday the Minister of Foreign Affairs
speaks for the Minister of Foreign Affairs. National security is part of the government of Jamaica. It can't be that Minister Chuck and Attorney General Malawu Ford are on different lines, and that represents how the government operates. It's one government. One government. So I want to know, Mr. President, I go further. Based on what the minister said, Mr. President, can I be allowed to address you? Mr. President, I'm trying to get your attention. I know you're distracted by the noise on the other side. You're not distracted by their noise. Good. Mr. President, Kedi, leave him alone. Kedi, you're not at... Kedi, leave him alone. Mr. President, the minister spoke this morning about seeing video of the men and the complaints. Part of the video, and I want to ask the minister this, if part of the video you have seen dealt with the fact that these men were given slimy food, they were shackled, left out in the sun, the rain, the dew, and really were left, these Jamaican brothers of ours were kept in slave-like condition. Is that the video you saw too, Minister? Because you mentioned seeing a video, and I'm asking, is that the video you saw? Before I get to the next one, yes.
I know that I have not watched the whole of the video, but I understand that what I saw was shocking. Mr. President, I want to just advise, just ask the senators to be responsible lest they believe that they are helping a situation and they are in fact doing the opposite. The ministry is making inquiries of the other relevant agencies and departments. There is a case before the court of the United States through which these gentlemen are seeking justice. We on the government side are making inquiries because we do not know enough. I have made a statement to ensure that the people of Jamaica know that we are looking at the matter, to take the opportunity to remind them that where they have difficulties, that their reports about maltreatment should be taken to the nearest consulate, embassy, or mission, or high commission, or on their return brought to the attention of the Ministry of Foreign Affairs and Foreign Trade. This is whether there is a deportation at hand or not, because there are different considerations. So, Mr. President, thank you.
Mr. President, she may wish to thank you. I want information for the people of Jamaica on whose behalf I'm here. Mr. President, it's clear the minister said that the detention amounts to human rights abuse. From what I've heard, it amounts to slavery. And there are international conventions against slavery and slave-like condition for the citizens of the world. They push us about human trafficking. They can't take our people and treat them like slaves. So I want to know, Mr. President, as the Ministry of Foreign Affairs call in the officials of the U.S. Embassy to explain the abuse and slave-like treatment of Jamaicans held unjustly by the U.S. authority. Are we calling the U.S. authorities to find out from them what happened and why did they treat our people in this inhumane, in this abusive of human rights, in this slave-like condition? I want to know if they did that, because otherwise they would have once again abandoned the citizens of Jamaica to Uncle Sam.
Don't answer that. I'm telling the minister don't answer it because she answered it already. They say that they are investigating the matter. Brought to their attention yesterday and they are investigating it. And I'm directing the minister not to answer it because she answered it already.
I want to know if they're calling the U.S. officials, because the country needs to know what has this government done to protect our citizens. That's what I'm concerned about. What has been done to protect our citizens. Right? They can't come here and make a statement and hide behind inquiring. They need to tell our people, tell us what they did about those poor fishermen.
Did you hear the minister say? Did you hear the minister say that the matter was brought to the attention of the ministry yesterday and they are investigating it?
And so I want to know if when part of that investigation is calling in the U.S. Embassy.
That's not the question. That's not the question that you asked. Don't.
That's the question I asked.
Senator Brown, I will not shout at you and I ask you don't shout at me. That's not the question that you asked.
Mr. President, let me not shout at you. Mr. President, could I have an answer to the question? Because I'm not shouting. Whether the U.S. Embassy have been called in by the Ministry of Foreign Affairs, which is a normal part of protocol activity when there are difficulties, to call in to ask for their side of the story. Because this impacts, Mr. President, I hope I'm not shouting, this impacts the right and the liberty of our brothers, our black brothers. When we fly, when the U.S. Embassy fly a pride flag, when the U.S. Embassy flew a pride flag, the Attorney General tweeted about this. I want to know if we have tweeted, we have called in the U.S. Embassy on this issue.
Senator Brown.
Yes, sir.
You asked the question,
has the U.S. Embassy been
called in? In my view, the minister may answer that with one or two words. Yes, I can.
Mr. President, I wish to say that before I have ever called in
One minute. Senator Skeffrey, you have accused me of bias. Are you accusing me of bias?
That's a serious matter.
Are you accusing me of... No, that's not what I'm asking you. Are you accusing me of bias? Just answer the question, please, Minister.
Mr. President, before any responsible minister were to call in a representative, a member of the diplomatic corps, one would presume that that minister would have obtained as many facts as possible about the matter. I have indicated to the Senate that we're investigating. We're seeking to understand the case more because it only came to our attention yesterday. Mr. President, I have therefore acted responsibly and have not yet called in the charge.
Is the minister giving us an assurance? Is the minister giving us an assurance? We have talked about Windrush and we curse the British. Is the minister giving us an assurance that after our investigation, she'll be calling in the U.S. diplomats to account for the slave-like condition that they treated our brothers and sisters
Mr. President, a point of order.
For the slave-like condition.
A point of order.
For the slimy food that they serve our brothers and sisters. For the shackle that they put on them.
Senator,
rain
a point of order.
or shine. Right? President has abandoned the chair.
This is Jamaica, you know.
And
what you're doing is irresponsible.
Because it appeared to me that this government doesn't like to talk about the protection of the citizens of the country. Sorry?
You're attacking the country in kind of references.
I am talking about your government who has been slack and incompetent in defending the Jamaican citizen. That's what I'm talking about. That one Jamaica include those 5 people who were treated like slaves. That's my concern. 5 Jamaicans treated like slaves. And you come here talking about investigation, inquiring. Right? That is what I'm talking about. 5 Jamaicans. Right? 5 Jamaicans that you are too comfortable.
All right, Senator.
Too comfortable in the
Senator, please, can we just calm this down? Can we calm this down, please? Can we just 30 seconds of calm? Just let's relax. Gentlemen, please.
I think there's a question I asked about whether we get
I heard it, sir. I'm still in a state
You're
of
trying
calm.
to calm them down now that the president has run out of the chamber?
I'm still trying to calm you down.
Mr. President, allow me to simply say
Yes,
that we are
Minister.
investigating. I will give him no such assurance. We are investigating and will act appropriately based on the facts that we're able to ascertain.
The question, just a minute,
Mr. President.
Just a minute, sir. Just a minute. The question has been clearly answered. You might not like the answer, but it has been clearly answered, and I rule that it has been clearly answered. I take your next square. Yes, sir, please. I must have been walking up here. I missed it.
Because that's all I've been asking. But then again, I understand where she's coming from. The hypocrisy when it comes to the Jamaican people's right. That's where she's coming from.
Mr. President, what is the question? He is really out of order now, Mr. President. Mr. President, I have stated that the matter is of deep concern for us and we are inquiring and investigating. The bullying that I refer to is the shouting and really unworthy behavior in this chamber.
Mr. President.
Thank you. Can we proceed? Announcements?
Laid on the table of the Senate today are the following. Ministry Paper number 26 of 2019 entitled National Plan of Action for an Integrated Response to Children and Violence. Ministry Paper number 27 of 2019 entitled Certified Appropriation Accounts Head 0500 from the Auditor General's Department for the financial year 2016-2017 and 2017-2018. The law reform zones of special operations, special security and community development measures, the Denham Town Community Zone extension of period of operation number 3 order 2019. The law reform zones of special operations, special security and community development measures, the Denham Town Community Zone extension of period of operation number 3 order resolution 2019. The law reform zones of special operations, special security and community development measures, the Mount Salem community and environs in the parish of St. James Zone, extension of period of operation number 3 order 2019. the law reform zones of special operations, special security and community development measures, the Mount Salem community and environs in the parish of St. James zone, extension of period of operation number 3, order resolution 2019. Annual report on audited financial statements of the Jamaica Ultimate Tire Company Limited for the financial year 2016-2017. Annual report on audited financial statements of the Jamaica Railway Corporation for the year ended March 31, 2017. Annual report on audited financial statements of the Toll Authority of Jamaica for the financial year 2017-2019. The INDECOM's third quarterly report for July to September 2018. The INDECOM fourth quarterly report for October to December 2018. The INDECOM first quarter report for January to March 2019. And the Public Procurement Act, the Public Procurement Registration and Classification of Suppliers Regulations 2019.
Mr. President, I'm just seeking your leave to ask a quick question regarding Ministry Paper number 26 that was tabled today. May I, sir? Thank you. Mr. President, this paper speaks to the National Plan of Action for Integrated Response to Children and Violence. And I note that a document has been tabled alongside the Ministry Paper, this other document called One Love Jamaica Pathfinder Country. I asked the question, sir, because 2 weeks ago, a circular was sent out to schools, asking schools or instructing schools that the ministry, in collaboration with the Seventh-day Adventist Church, will be establishing Pathfinder clubs in schools. And I wondered, I have gone through the ministry paper and taken a cursory glance of this document. And nowhere in it do I see any consultation with the Jamaica Council of Churches. And I wondered, sir, whether there was in fact any consultation and whether establishing a Pathfinder club which is associated with a denomination is in fact the way to go, considering that all other denominations, certainly I can speak for the Anglicans, that they also have youth clubs. And so I wondered,
Senator Vince, you know, I'm not in a position to answer it, but you could put your inquiry in the form of a question that could be referred to the appropriate ministry.
Very well, sir.
Thank you. Bills brought from the Honourable House of Representatives.
The following is a message from the House of Representatives to the Honourable Senate. I have the honor to advise the Honourable Senate that on the 11th day of June 2019, a bill entitled An Act to Establish a Body to be called the Information and Telecommunications Authority to promote improvements in information and communications technology service management in all public bodies, to transfer the functions of eGov Jamaica Limited and the Office of the Chief Information Officer to the Information and Telecommunications Authority and for connected matters was passed in the House without amendment.
Mr. President, I signify my willingness to take charge of the bill.
A bill shortly entitled the Information and Communications Technology Authority Act 2019 read the first time.
Mr. President, I beg to give notice of second reading of the bill.
Thank you, Minister. Petitions, papers, reports from committees, notices of motions given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. Be it resolved that the Public Procurement, Registration and Classification of Suppliers Regulations 2019 under the Public Procurement Act, which was laid on the table of the Senate on the 14th day of June 2019, be affirmed.
Thank you. Okay, thank you very much. Questions and answers to questions? Motions that may be made.
I was just trying to get an indication from the minister if he's ready with the answers. When? No, this is between me. Just wait. No, I'm not here. Yeah. Could you, you know? Yeah. No, not here. President. My mother taught me courtesy, and she taught me that I shouldn't shout at presidents, and neither should I speak when presidents are not paying attention.
Let me explain something to you. Let me just say something, right?
To say something, I don't think, knowing you, I don't think you want to say it. So, Mr. President, President is the President. Mr. President, on this question notice papers, question number 1, standing in my name, the minister a couple of weeks ago indicated that he would be able to answer it next sitting. Next sitting came, he didn't answer it, and he said soon thereafter. I'd like to get a sense, President, because that's when I shout is when I think you're not paying me attention. I'd like to get a sense as to when the minister would be in a position to answer these simple questions, which was asked a long time ago, and we brought them back after the sitting. So that's, if you can hear me, President, that's what I'm really trying to find out.
Mr. President, upon receipt of all of the information relating to the questions, I'll be able to answer the questions to the Honourable Senate. And I will do all that is necessary to expedite the process.
You're a good boy, I'm not meant to harass you.
Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. I love this bit. Public business.
Mr. President, it is intended today to continue the debates in respect of the Trusts Act 2019 and the Act to amend the Food Storage and Prevention of Infestation Act and for connected matters. But prior to that, Mr. President, last week it was noted that the report of the Regulations Committee had been tabled, and there is a matter which we could dispense with fairly quickly. I ask that the chair of the Regulations Committee take this matter. Thank you.
Thank you, Minister. Chair.
Mr. President, be it resolved that the report of the Senate Regulations Committee on its deliberations, the Foreign Nationals and Commonwealth Citizens Employment Work Permit Fees Amendment Regulations 2019, which was laid on the table of the Senate of the 7th day of June 2019, be adopted. Prior to its adoption, Mr. President, I'd like to just bring to your attention that the matter was taken at the Regulations Committee. It was non-contentious. Information about the general functioning of that department was brought to our attention. The regulations primarily look at the fees being brought in line with those being charged in the rest of the region, fees being brought in line with the economic costs, as the last time they were reviewed was 2014, and the change to the structure which allowed refunds to be given for those who applied in the past based on the administrative ability to do so. So, Mr. President, I ask that this be adopted.
Membership have heard members of the Senate have heard the motion and the request for the affirmation. Those in favor?
Before you move, sir, I just want to comment on it. It's clear that the country, Jamaica, treats foreigners well. We give them accommodation. We provide them with jobs. I wish, Mr. President, that we would insist that foreign countries treat our citizens better than what we have seen in the last 2 days of our fishermen who are working honestly was treated. Want to know what I talk? Because I have 30 minutes, you know, and I'm capable of using every second in it. So just allow me to make the 1 minute thing I want to make. Yeah, I can make the 1 minute thing about how it is good that Jamaica, the one country we love, the beloved country, treat foreigners well. We need, by that standard that we set for foreigners, to insist that our working folks, fisher folks, for example, are so treated and not kept in prison for 10 months, and we don't hear reports being made to our consular services. When we hold Jamaican foreigners here, we report them to their consulates and their embassy so they may come and look for them in accordance with international treaty. And so I am offended that a country could hold 5 of us for 10 months in prison and no communication made to the consular services, to the government, to the Ministry of Foreign Affairs. In fact, the family of those 5 thought they were dead. Were prepared to think.
Senator Brown, there is a motion. Hold on a minute.
It's a work permit I'm talking, the treatment of foreigners.
There is a motion. No, there is a motion on the floor.
Mr. President,
one minute. There is a motion on the floor, right? You want to make a statement about the fishermen again? Because you have done it already, you know.
The need for reciprocal treatment of foreigners in the way we do under our work permit act. You see, Mr. President, let us be clear. It is easy for some of us to put more interest in a rapist in Qatar
Mr. President, point of order.
than in 5 poor Jamaicans.
I don't need it.
I have seen it.
I don't need it.
But this is misleading, Mr. President.
Your intervention, Senator Samuda. There is a motion. There is a motion on the floor, and I'm going to put the motion.
So I am supporting the motion, sir, which is why I rise. I'm supporting it to say we treat foreigners good. They should not treat our people as bad as they did.
There is a motion on the floor. Those in favor? Against?
Mr. President, it is now intended to proceed with the committee stage of the Food Storage and Prevention of Infestation Act. The debate, which I understand had been closed. Matter is being piloted by Senator Charles Jr., and he will continue in that regard this morning.
Thank you, Minister. The Minister Charles did in fact begin the debate. It was suspended until, I think, last meeting and then again for today. So it can continue. Minister Charles?
President, the only challenge is that we have not had the opportunity to even look at the amendments. And if respectfully, just to look at them to see if they had, it would be easier if we did. If we dealt with the continuation of the Trust Act, maybe we could just glance at them first. Is there a problem with that?
Mr. President, I think that if my colleagues glance on the amendment sheet, you'll realize that you won't have much difficulty as it relates to the cohesion that follows from the debate that we had at the last instance. I understand the need to go through with some amount of intricacy to examine it, but if you would permit us, I think that we wouldn't have that much difficulty. And I will take the time during committee to also make reference then to the issues that were brought up as we make reference to each clause and to explain why we treat with it in a particular way. That will assist as we go through the amendment sheet. And it's not very voluminous or complicated either, because most of what you're seeing attached to it is new schedules which flow actually from recommendations made from us together as colleagues. So if you would permit me, what I will do is simply summarize, close debate, and then move quickly into committee stage.
common courtesy of sending it electronically to us. So that we don't...
It's the correct phrase is circulate.
Sending it electronically to us.
No, circulate a copy.
I hear why you are saying that. You have had a discussion elsewhere.
Exactly.
You have had a discussion elsewhere. But for now, since I wasn't privy to your discussion, I want us to send it electronically. So that, Mr. President, we're not ambushed. We're not taken suddenly. I know that I'd like to urge Mr. President, because again we got a statement today that wasn't circulated. Can I urge you, Mr. President, in my quietest of voice, to urge the government business leader to do the other bill, start the other bill, and let us come back to this, which will at least give us a chance during the debate of the other bill to look at the amendments. I think that's only fair, my friend, and I urge you so to do.
Senator Brown, the minister was fairly reasonable in terms of adjourning for quite a while to go through it. And if he has assured us that if there is you can assure us that if there is an issue, we'll perhaps defer that particular issue.
That has been our general consensus. It has. Hold on.
Senator Charles, proceed. Let's proceed.
Let us proceed.
If there is an issue,
permit us to proceed.
If there is an
I don't
issue,
think we'll have much difficulty. Mr. President.
Sure, you can deal with it.
Mr. President, I have confidence in my colleague on that side. The way in which the entire debate was conducted under his leadership was in the highest tradition of the Senate, and if he assures me that he will deal with this in a particular way, I accept it.
Senator Charles, continue, please.
He's not here on his phone today. Let's do it before.
No, he did.
He's a deputy leader.
Senator Charles. Yes. Just consult with the clerk. Where did we leave off?
No, you were actually correct. I think I indicated that we closed, but you were correct. We suspended.
Make the senator answer, man.
We went to committee.
Committee, yeah.
I don't think we did. I think we're about to go into committee. Okay. So I'll go straight then to ask for the bill to be read a second time, if that is it. Right? Second reading of the bill.
The question is that the bill be read for a second time. Those in favor? Against? Madam Clerk?
A bill entitled An Act to Amend the Food Storage and Prevention of Infestation Act and for Connected Matters read a second time.
The question is, I am aware, Madam Clerk. The question is, and I shall now resolve the Senate into a committee of the whole Senate to consider the bill clause by clause. Thank you, Madam Clerk. Thank you, Mr. Marshall. I put clause 1 of the bill.
There are no amendments to clause 1, Mr. President.
There being no amendments, those in favor?
Aye.
Against? Ayes have it. I put clause 2.
There's an amendment to clause 2 insofar as the definition of device, Mr. President, is expanded to include any readable electronic device. This is arising from a recommendation from Senator Skeffrey.
So just tell me what it will now read.
It will read, as well as I don't need to read it up, Mr. President. The amendment sheet makes reference to the amendments.
Which I could follow if I had one.
Yes. Yes, also in the definition of infestation, the words as determined by the inspector are inserted to indicate that it is the inspector who determines what is to be considered as being infestation. Senator Brown, you had raised that issue. The definition of place also is amended to remove the reference to shipping container. You recall the discussion we had about that, as this is already provided for in the Principal Act.
Thank you very much. So there are essentially 1, 2, 3 amendments to Clause 2, which appear on the amendment sheet. And I ask your approval for those. Those in favor?
Aye.
Against? The ayes have it.
Mr. President, there are no amendments to Clause 3.
Thank you, Minister. I put Clause 3. Those in favor?
Aye.
Against? Sorry. I need to recommit Clause 2. If Senator Morris was here, he would have picked it up. There are amendments to Clause 2, and you agreed the amendments, correct?
Yes.
So I now put Clause 2 as amended.
Aye.
Okay, so I put Clause 2 as amended. Those
Aye.
in favor? Clause 3, you said there are no amendments. Clause 4?
Clause 4, there's an amendment, Mr. President. Section 5 of the Act is amended to replace the itemization of the specific risks that may exist in the storage and transportation of food with general terms where there is an immediate or potential risk that infestation or contamination. Senator Sinclair had raised the issue of having the words or contamination inserted after the word infestation to ensure that both areas were included, and that was done.
Thank you, Minister. To clause number 4, there is amendment on the sheet to clause number 4, and I ask your approval therefore. Those in favor?
Aye.
Against? So I ask for the approval of clause 4 as amended. Those in favor?
Aye.
Against?
Yes. Clause 3 was put.
We are not at 3. I said 4.
No, a question is asked as to whether you had put Clause 3. And I'm saying, yes, you had put Clause 3. Clause 5, there's no amendment, Mr. Chairman. Aye.
Against? Ayes have it. Clause 6, there are substantial
There is an amendment, Mr. President. The amendment to Section 7 of the Principal Act will now expand the persons to whom an operator who fails within the Act must give written notice if it comes to his knowledge of any infestation or contamination. Under the Principal Act, notice was required to be given to the minister only. And my colleagues had raised an issue as to whether or not the Chief Food Storage Officer ought not to be also included. I have no difficulty with that, Mr. President, and so that has been amended. Further, the word premises is substituted by the word place, which includes premises in its definition.
Thank you very much. So there are amendments to Clause 6 which appear on the sheet, and I ask for an approval from the Senate of those amendments. Those in favor?
Sorry, Mr. Chairman, in 6A, where it says, no, it is in the original bill that I'm inquiring. It's an inquiry where it says in 6A and it makes reference to Section 7 of the Principal Act. It says minister, inserting immediately after the word minister the words and the Chief Food Storage Officer. Should that be and or it has to be, the report has to be made to both?
And it is and.
And we are certain that will.
Oh, so it's meant to be and.
It's meant to be and.
Okay,
Yes.
thank you very much.
Thank you.
So there are amendments to clause 6 on the sheet. Those in favor of the amendments?
Aye.
Against? Clause 6 as amended. Those in favor?
Aye.
Against? Ayes have it.
No amendments to clause 7, Mr. Chairman.
I put clause 7 of the bill. Those in favor?
Aye.
Against? The ayes have it.
There is an amendment to clause 8, or a number of. Take it one by one. Mr. President, at the last instance, Senator Brown had actually raised some issue as it relates to the clause 8, that it speaks to the first offense before a parish judge in the case of a first offense, a fine not exceeding 3 million. And then it says, if any damage is caused as a result of the commission of the offense, a fine not exceeding 4 million. And the question was whether these are two different things, and for it to be clearly stated. So the comments have been duly noted, and the section was amended to clarify the language, and you'll see that on the amendment sheet. At Amendment 9.1, which provides for now also a general offense clause, where no specific penalty is provided as distinct from the other subsections 9.1a, subsection 1 and 2. Also, Mr. President, there is another recommendation that was made, I believe by Senator Brown as well, as it relates to a question about an amendment of Section 9 of the Principal Act in Clause 8b, and why have the same punishment for the two offenses which are not the same. And I think we were referring to endangerment versus the causing of actual harm. And so those comments were also duly noted, and the offense relating to endangerment was removed, and a definition of damage was inserted to create one offense, which would be a more effective way of addressing it in the bill. Another issue was raised, Mr. President, in this clause as it relates to difficulties that arise on the issue of proportionality. This was a matter which I don't think anyone had great difficulty appreciating. This was actually perhaps the matter Senator Knight raised when he, in discussions with me, was discussing the issue of proportionality, and a lot of time was taken by our technical team, who I must thank, in relation to laying out some of the specific offenses that were to be identified in the Act and regulations, and laying out the appropriate penalties to be applied, which are proportionate to these offenses, as opposed to the general offense and penalty that we had before. So what we end up having, Mr. President and colleagues, as it relates to the treatment of offenses, is we have specific offenses, specific penalties. We also have a general provision for those offenses that are not provided for, because as I had relayed to you, Senator Knight, in agreeing with the matter, is that we may not be able to contemplate for everything. So as we have specific, we really should still keep a general provision. We have kept that. And we have provision for the disciplinary measures, suspension and revocation, etc., in Regulation 23. So we have a very comprehensive approach to the treatment that has acknowledged all of the recommendations from this side. I think also Senator Sinclair did raise an issue in this regard as well. And all of those are presented on the amendment sheet, Mr. President.
Any comments? Thank you very much.
A question, Mr. Chairman. In the circuit court, are we going with a jury, or is it a judge alone? For I mean, the penalties that you have in the parish court
Yes.
is obviously with a judge alone, and they are significant in any event.
I'm glad. Let me. Your indulgence,
If
Mr.
it is,
Chairman.
if it is that you are going to the Supreme Court, there would be an option.
There is an
an
option as it is.
But there is
now.
nothing that is specifically saying
For
it
this.
here. Is that what you're saying?
You're saying that it's not detailed?
No, what I'm saying is that you have certain offenses. The law reform fraudulent transaction goes before a judge alone. In the circuit court, it is specified. In other matters, you have the option, but it would be the defense that would be determining whether it's going to be judge alone or jury. Yes. In this particular instance, are we saying that it just goes to the circuit court for this type of offense? Or judge alone, or are we going to have to depend on an agreement being arrived at for this offense?
I got you.
To be tried. I just get the impression that, and I've seen, I mean, some judges in the circuit court with certain offenses that would come and would engage a jury. And they are of the view that it shouldn't be there. They send it back to the parish court if the parish court can deal with it.
So that's a question for us, but am I advised that if it is to be without a jury, we would have to specify that?
I think it should be specified.
So it's a matter for us
indictment
as
before
to
a circuit court, and including their reference to judge alone, a judge alone trial somewhere.
I don't think so. I mean, I'm not certain that that is the route that we would want to take, but if you believe so, what's the basis?
The basis of putting matters before the jury is because it is felt that there are some matters that are of such a technical nature that it is preferred to be put before a single judge or for some other security reason. Isn't that correct, Senator Knight? What is the imperative of putting this matter before a judge alone? Is it because there are no security issues? Is it because the matter is so technical that it would require a particular mindset?
Well, these are matters that might be adequately before a jury, considering the gravity of the extent of impact of an offense of this nature. So I don't see that it is necessary, but I yield to you if you believe so.
Mr. Chair, this was a question. Many times I sit here and when amendments are proposed, we reference the policy. So what's the policy that's guiding this particular bill in terms of this specific issue?
Your indulgence, Mr. Chairman and colleague. What I would do is perhaps I could confirm the position in that regard. I know that Minister Chuck had agreed or had not disagreed with a position in relation to judge alone. And if we were to do so, it would require us to make amendments to these amendments. It's a matter for us here as well. We have senior counsel here and other senators who
but
can
a follow-up question.
Yeah, it wouldn't be a policy issue in that regard only.
No, so I'm having a follow-up question. As the minister piloting the bill, what was the intent in this particular provision?
As it relates to judge or...
Sure, what's the intent? You must have had some deliberation as to what the preference ought to be, or what should take place. So what's the intent? Because the intent drives the provision.
Senator Skeffrey, sorry, once it says trial in the circuit court, there's an option now to have judge or jury. There's an option. It requires defense and prosecution.
Yeah, so I would propose we stick to that now.
If you proceed with it as it is, then that option would be open.
Exactly. And I also recommend.
And it would depend
up to the parties.
It would depend on the circumstances, because as I said, the gravity of circumstances relating to these kinds of matters and also the nature is wide-ranging. And so I believe that the option is the best approach. That has been my...
And keep it wide.
That's
my proposal.
That has been my approach.
So that's okay with you, Senator Sinclair?
Having heard the comments, I don't have a quarrel. I was just asking whether it needed to go that way. But you have the option, you can use it.
All right. Thank you very much. So that I can put the amendments to clause 8. Those in favor?
Aye.
Thank you. And I put clause 8 as amended. Those in favor?
Aye.
Minister?
There's no amendment, Mr. Chairman, to 9, 10, or 11. The remaining amendments would arise in the
with the concurrence of the membership. I put clauses 9, 10, and 11. Those in favor?
Aye.
Against?
And as I had indicated earlier, Mr. Chairman, consequent on the recommendation to have specific offences and penalties as laid out, the regulations have delineated the 6th schedule which has been inserted with same, and so those are for consideration by all colleagues.
So let me just ask if the membership would like 2 minutes to just run through the regulations. Okay? So I'll give the committee an opportunity to just. Okay, thank you very much. So let me put the schedule of the bill. Those in favor? Against? Yeah, I didn't. Thank you, Ms. Curtis. Let me put the amendments to the schedule. Those in favor? Against? The ayes have it. Let me put the schedule as amended. Those in favor? Against? The ayes have it. I put the title and enacting clause. In favor? Against? The question is that I do report the bill as having passed committee stage with Ms. Curtis. 1 minute, please. The question is that I do report the bill as having passed committee stage with 24 amendments. Those in favor? Against? Ask for third reading. Minister, you're asking for third reading?
Asking Mr. President that we now read the bill a third time.
Thank you very much, Minister. The question is that the bill be read for a third time. Those in favor? Against? Madam Clerk?
A bill entitled an act to amend the Food Storage and Prevention of Infestation Act and for connected matters, read a third time and passed.
Thank you. Senator Hill, CFC Minister Johnson. Yes. CFC. The next, just waiting for the minister to introduce the Trust Act. Thank you very much, Minister.
Thank you, Mr. President. Mr. President, it is now intended to continue the debate on the Trust Act 2019. As you would recall, the debate had been opened at the last sitting, and the opposition would have the floor to continue the debate.
Thank you very much.
Mr. President.
Thank you, Senator Fraser-Binns. Here you go.
Sir. Mr. President, I wish to make some very brief comments on this bill entitled, well, the Trust Act 2019, and seeks to provide the establishment and operation of trust services in Jamaica in relation to both Jamaica and foreign trust. Let me start off, sir, by saying that the opposition supports this bill, and it represents another plank in the continuation of legislation aimed at establishing Jamaica as an international financial center. Admittedly, Mr. President, it is an area that a lot of us do not delve into. And in reading this, I called my contemporary and I said to her, did we do equity and trust in school? Because somehow, I know we must have done it, but the concept seems so foreign, with the exception of perpetuity. It seems so foreign. But notwithstanding that, Mr. President, we believe that this is a very important piece of legislation, and we are hopeful that it will be passed today with some comments that I'm praying for the acceptance of the government side. Before I delve into the content of the bill, sir, I really want to commend the Jamaica International Financial Services Authority, JIFSA, for the work that they have been doing to attract new investments and indeed positioning Jamaica to be the international financial center of the world. And the commendations really extend to both sides. We commend former Minister of Justice Golden for the work that he did under the last administration. And he marshaled several pieces of legislation in this pursuit. But we also must commend Minister Chuck and the Minister with portfolio responsibility, Prime Minister Holness, for continuing this trend and for bringing this piece of legislation to the Senate so we can review it today. There is no doubt that in establishing an international financial center, most investors will assess the various commercial laws in the country, including the trust law. And unfortunately in Jamaica, we do not have a specific piece of legislation that deals with trust apart from the Trustee Act, which is very outdated, and the Trustee and Executors Act. And so, to a large extent, what we have done, as the Minister mentioned when she spoke last week, is that we have relied on the common law position, which has its own weaknesses. For starters, it is quite ambiguous, and sometimes we have to rely on case law to achieve certain objectives or to help us in ventilating certain issues. And so we welcome this piece of legislation. But in welcoming this legislation, I want to make some brief comments on some of the provisions and commend some recommendations to the government side for acceptance. I want to start at page 3. And at page 3, under the definition, let us look specifically at the definition of a child. And let me just say, and I will divert a little, but when I look at this, it confirms in my mind, or it reminds me, and Senator Scott and Minister Johnson Smith served on the committee, as well as Senator Longmore, that there are so many definitions of a child. And at some point, I am hopeful that we will agree to one definition. But for the purpose, let me get back to the purpose here. It says that a child, I'm looking at part B that says, a child for this purpose is a person who is under the age of 21 years, where that person is a subject of a court order requiring the payment of sums for maintenance for education purposes pursuant to the Law Reform Age of Majority Act. Mr. President, the first proposal I make is that this definition be amended to be aligned to the definition that is found in the Maintenance Act, which goes up to the upper limit of 23 years. And I don't think I need to say more, Minister. 23 years as opposed to 21 years. I also, the Maintenance Act, it provides, Section 16, I believe, of the Maintenance Act. Yes, Section 16 of the Maintenance Act provides that where a child is in education, then it goes until 23. So I'm recommending that for education purposes only. Yes. At page 11, clause 6, subsections 3 and 4, I believe, sought to deal with the issue of the anti-heirship rights or heirship rights. And let me admit that when I saw this term, I was forced to go and Google and read upon this and understand exactly what it is. But based on my understanding of it, I think that, and essentially what it is, Mr. President, is that it provides that, page 11, clause 6, it provides that a judgment made in another jurisdiction relative to the trust property would not be page 11, subsection 4, big A. Yes, right. That says the trust or disposition by way of foreign heirship rights. And the concept of heirship rights has to do, as I understand it, that judgments made in a foreign country would not be recognized or enforced in the trust country. And if my understanding, against the trust, and if my understanding is correct, Mr. President, then I think this is a positive inclusion in the legislation and can only inure to the benefit of Jamaica. Because when persons are setting up trusts and businesses are setting up trusts, they want to ensure that the country where the trust is established will protect their interest and the subject matter of the trust. And so I'm very pleased that we have included this particular provision. And Mr. President, I want to say that this provision also comes from the Guernsey law, which primarily, from which this bill has been modeled, and it is deemed, the Guernsey law is deemed to be the platinum standard. And when I look at the provision in the Guernsey law, when I look at the provision in the British Virgin Islands and the provision in the Cayman Islands, these are some of the provisions. And we all know that these three countries are three of the top countries for offshore banking and for trust. And so it is a provision that I fully support. At page 15, under clause 11, it speaks to the duration of a trust. And Mr. President, as you are aware, at the common law, a trust can fail where there is lack of certainty of duration. In other words, a trust cannot exist in perpetuity. And one of the improvements that have been done to the common law in codifying it and putting it in this bill is that it has moved against that common law position that says a trust can fail because there's no defined time. And it is now recognizing that a trust will not fail because there is no defined timeline. So it moves against the rule of perpetuity. And it is a positive provision. It is a provision that we support. Again, it's one of those provisions that you find in the jurisdiction of the Cayman Islands and the BVI and clearly in Guernsey Island. And this is what investors look for when they're making a decision as to where to establish their trust. A minor correction at page 16, clause 15, Minister. It says the interest of a beneficiary is personal property. I reckon it should be in personal property, because as is, it doesn't read clearly. So that's a minor correction. Clause 15 on page 16. Then I want to spend a little time and look at clause 16. And that clause and the clause following, at least the 225, deals with what is called a purpose trust. And essentially a purpose trust is one of those trusts where it is established for a specific purpose. But they're often, unlike other types of trust, is not a defined beneficiary. And I believe that it is because of the peculiar nature of a purpose trust why we have adopted the best principle of the enforcer and the protector. Again, this represents a departure from the common law and is in keeping with what exists under the Guernsey law. And when one looks, for example, at the establishment of the position of the enforcer, then we understand how important it is, because the enforcer becomes a critical player in a purpose trust. Because what the enforcer does is that he steps or he represents the undefined beneficiary and ensures that the purpose for which the trust was established is being carried out. And I think this is commendable. And not too far apart from the enforcer is the task of, the office of the protector, who in very simple terms represents the settler. And he ensures that the wishes of the settler is carried out. The wishes are carried through. He is in so many ways like a supervisor and provide guidance to the trustees on the administration of the trust. Again, this is another provision that you find in gold standard jurisdiction, and I am very pleased that we have sought to incorporate it in our law. At page 19, clause 19 looks at the issue of the trustee. And this is where I have a little discomfort, because it provides at clause 19 that except where the trust instrument provides for it, then the minimum number of trustees should be not less than 2. And this is another provision that clearly we may have taken from Guernsey. But it differs from what obtains in our neighboring islands, such as the Beaver and the Cayman Islands, where their minimum clearly is 1. And the discomfort I have is that even though the settler, has the power to state in the trust instrument that he wishes to have 1 trustee, where that is not expressed, then you are then called upon to appoint a second trustee. And I wondered, what is the magic of 2? I mean, if you're going to go for a minimum, why not 1? Why not 3? Why not 4? I don't know what's the magic, apart from just adopting it whole scale from Guernsey. So I shall like, Minister, if you could just give some guidance in that regard. At page 20, clause 22, it says, every trustee appointed by a court of competent jurisdiction shall, clause 22, and it goes on to say what the trustee can do. The issue I have here is that in the definition, it speaks to court, and it says the court is the Supreme Court. And I wondered why we're using the term court of competent jurisdiction. Is it that it is envisioned that another court will have jurisdiction in appointing the trustee? And I don't think that is the intent. Because if we're saying that the court is the Supreme Court, then, and right throughout the Act, the reference is made to the court, meaning the Supreme Court. So I wondered whether this term, court of competent jurisdiction, is an oversight. I think it is. And I recommend that it be deleted. And for uniformity, we keep the word court. The Supreme Court, exactly. At clause 24, subsection 2B, again, it's a minor recommendation, but it says if the settler is dead and cannot be found, and there are no other trustees, then the person appointed as trustee may apply to the court, which may make such order as he thinks fit. But if the person appointed does not act under subsection 2A or 2B, so I think that the but should go back to the margin because it is not a part of subsection 2B. Shall I go through that again? Subsection 2B ends at thinks fit. And then we should go back to the margin. Clause 24.2b. 24.2b at page 21. Right, so we should go back to the margin. Because as it is, it does not make much sense. Okay, great. Then I want to spend a little more time on clause 33, page 24. And clause 33 speaks to the requirement for unanimity of decisions. It says that at subsection 2, subject to subsection 3, and subsection 3 empowers the trustee, empowers the settler, that's the person who creates the trust, to determine whether or not the trustees should all act in concert or whether they can act by way of majority. So subject to that provision that the settler will put into the trust instrument, no function conferred on the trustees shall be exercised unless all the trustees agree on its exercise. I have a little problem because what I see here is administrative unworkability. Because if there are two trustees, going with the minimum, if there are two trustees and one decides that they do not want to, one decides not to agree with a particular decision in how the trust should be administered, then what happens? The trust can't be administered, notwithstanding the fact that the dissenting trustee can write his reasons. And so the trust really cannot work. And the only recourse I envision going through the act that the trustees or the trust will have is to go to the court for some order as to how the trust should be administered. And so I believe, again, in keeping with the desire to establish an international financial center, that this provision is not helpful. And I would want to recommend, Minister, that we change that to a majority, or where there is, where we have equality of trustees, for example, two trustees, then the decision stands. And if one trustee does not agree, then he can put his reasons in writing. But the trust should not. Page 24, clause 33. And clause 33, as I said, it states that decisions must be taken by, the functions of the trust must be executed by all trustees. And I'm saying that I believe that this is administratively unworkable. I'm further recommending that that provision be deleted for reasons I have said previously. But the provision that speaks about a dissenting view, that be maintained, because what it does, it allows the trustee who does not agree to state his or her reasons for not agreeing. Are we clear with that, Minister? Okay, no, I just want to make sure we can discuss a committee stage. At clause 40, that's page 27, it deals with the power of the trustee to give a power of attorney to a donee. And it says that trustee may, by a power of attorney, delegate for a period not exceeding 3 years the performance of any trust or function vested in the trustee. Again, I wonder what is the magic of 3 years? Why not 5 years? Why not 6 years? And I would love some answer. But I want to go further, because when I read this, I had some questions. So it is renewable pursuant to 40 subsection 2. But what is not clear is the renewed period a maximum of 3 years? Or is there a minimum period? That is not clear, and it is left to speculation. So I would recommend that for certainty, that a specific period, whether it's going to maintain the 3 years or a longer period, but a specific period be stated that it can be renewed for a further 3 years, but not in excess of 10 years. The drafts persons are better able to phrase it, but I guess you get the recommendation, Minister. Yes? 42. Yeah. Right. Okay. Then subsection 6 of clause 40 requires the donor, that is the trustee, the original trustee, to inform the co-trustees within 7 days of giving the power to the donee. But there's no provision, and I noticed throughout the Act that generally there are these mandatory things that the trustee must do, but there are really no provisions as to what happens when the trustee does not act. And this is an example. So if the trustee does not inform the co-trustees of the delegation, then what happens? We know what does not happen. We know that the delegation will not fail. We know that acts done by the donee will be validated. We know that because the Act provides for that. But what we don't know is what happens when if the trustee does not inform the co-trustees within the requisite period. Then clause 44 on page 30 speaks to remuneration of the trustees and the liability. Now, you know, you can't have the benefit without the burden, or you can't have the burden without the benefit. So that's my starting point. But interestingly, when I read it, I was like, but why? And for the record, the provision says that a trustee, unless authorized by the trust instrument or by consent in writing of every beneficiary or by an order of the court, then the trustee is not entitled to any remuneration for his services. And I'm just saying quickly that he can recoup for expenses incurred, but he can't be remunerated for his services. And I have a little challenge with that. And the challenge I have is, and I like to compare it to an executor, because we know that by law an executor is entitled to a percentage for his work or his services, and that is usually tied to the Administrator General. As I understand now, it is 6%. So if an executor who performs tasks more often than not for a shorter period and perhaps less involved than the trustee is remunerated, then I cannot understand the reason why the trustee is not remunerated, save and except for cost incurred, but not for the services. So, and his duties are more onerous, absolutely. Absolutely. So, Minister, in your response, I'd be very grateful to find out the thinking behind it. Maybe then you could allay my discomfort, but I'm very uncomfortable with this. And I really believe that the trustees should be remunerated for their services. I want to turn quickly to clause 50, which is on page 33, and it goes on to 34. And this clause deals with lien, and it comes, clause 50. Clause 50? And it's a nice segue into what I just spoke about, because as I said earlier, the trustee can be reimbursed for expenses associated with the execution of the trust property or the trust. But what's interesting here is that he can register a lien on trust property, but not on real property. And again, I want to understand the reason for that. Because if you ask me, to a large extent, the real property, which forms the subject matter for trust, is arguably the best property for which the lien should be registered. And I do not understand the reason for it. And I want to go a step further. I'm talking about real property, not necessarily limited to, not having to do with Clause 50. But as it is now, you can establish a trust for real property. And a lot of us in our vacation establish trusts where you have for real property. But interestingly, the trust that is established is not endorsed on the title. So I buy a property and I want it for my child, but I don't want to put my child's name on it. And I go ahead and I create a trust for the benefit of my child using that subject matter. All I have is a trust deed, or all the trustee has, rather, is a trust deed. But there is no record outside of that on the title that says a trust is here to establish for the benefit of Jonathan or Nathan. And I know this is not necessarily the place for that amendment. It's something that we'll have to look under the ROTA, the Registration of Titles Act. But I'm hopeful that as we continue the slew of amendments and passage of new legislation, that is something that we can look at in the very near future. But I commend to you, Minister, Section 50, Clause 50, sorry, for your review and explanation as to the reason why the lien cannot be registered on real property. At Clause 54, there are certain rules that are applied or being proposed. And it says, where a trust or an interest under a trust is in favor of a class of persons, then subject to the terms of the trust, the following rules shall apply. And the one that caught my attention most was 54B, that says a woman over the age of 60 years shall be deemed to be no longer capable of bearing a child. Now, I don't know where that comes from, admittedly, but I don't think it should be there, because I was reading and I know that earlier this year, a 72-year-old lady gave birth to a bouncing baby boy, healthy and all. So Senator Braham, whether or not we think it is right, it is a fact, and I'm sure Senator Dr. Longmore is here, and she can tell us all the advances in technology that allows for these things to happen. So I'm not going to...
Senator Braham, wasn't it Ruth who bore a child at 107?
There you go. Not to
was it Ruth? Who was it?
Huh? Well, Mr. President, that's, you know the Bible, man. but the fact, though, the fact Senator Braham is notwithstanding her own personal views on this matter, I wondered whether this is a provision that rightfully should be there. And I don't know the purpose, so again, Minister, in your response, you may be able to guide us as to the thinking of the committee and the government when that determination was made. What really is the mischief? And I quickly want to go to page 39 at Clause 60, subsection 1, which speaks to the termination of trust. And it says that once a trust is terminated, and I'm paraphrasing, then it should be distributed within it shall be distributed within a reasonable time, subject to the provisions in the trust instrument or the trust deed. Again, I see no consequences for failure to do this. And I raise the issue because it doesn't say may, it shall. It mandates the trustee to do certain things. But I'm not seeing where, if the trustee fails, what recourse, unless we're going to be looking at section, what recourse the beneficiary has, or what sanctions, unless we're going to look to section 65 for help, which tells us that, you know, we could go to the court, and if that is the case, if you look at section 65, sorry, clause 65, if you look at clause 65, then even if one seeks to to find recourse from the court under this section, it is so worded that I believe that it would not be helpful, because it speaks to where a person does not comply with an order of the court. And to that extent, my understanding is you can only get this remedy under section 65 where there is a delay or a default of the court order. So I recommend, therefore, that clause 65 to be reworded to allow any recourse at all to be taken to the courts and not limited to where there's a default in carrying through with the court order. Clause 70, that's page 44. Again, I have no problem with this provision that speaks to where the trustee, where there's no trustee appointed who lives in Jamaica, resident in Jamaica, that the court has the authority or the power to so appoint. I only recommend, for the abundance of caution and for clarity, that a provision be inserted to say that the person so appointed shall have the full powers as one that is appointed by the settler. So that's, or perhaps it is understood as is, but I will be guided. At clause 72, again, another of my discomfiture.
Kindly repeat the clause for me, Senator.
72.
72. Thank you so much.
That's page 42, sir. 45. And at that particular clause deals with the power to make beneficiaries indemnify. Essentially, it has to do with where the trustee commits a breach of the trust by the instigation or the concurrence of the beneficiary. Whether
Mr. President, the Speaker's time having expired, may she be permitted to complete such time as may be required to complete her presentation.
Those in favor? Aye, the ayes have it.
Thank you. Thank you, Mr. President. Thank you, Minister. So I'm looking at clause 72, which speaks to the concurrence or the instigation of the beneficiary with the trustee to commit a breach of the trust. And the discomfort I have says whether or not the beneficiary is a child or a person under legal disability. I am uncomfortable with that because we don't know, well, as it is now in law, we accept that a child under 12 is non-compos mentis. So the child goes up to 18. So I would recommend, therefore, in keeping with that thinking and the law, that this provision be amended to say whether or not the beneficiary is a child over the age of 12 years old. And there is a reason. There's a reason why we do not attribute legal responsibility to children under the age of 12. Because the thinking, again, Dr. Longmore is here to help us with the mental part of it, but the thinking is that that child is not sufficiently developed to fully understand the concept of right and wrong. And in my mind, how can you attribute responsibility or liability to a child because the child says to an adult, do this, and this act.
And which gospel are you reference?
Pardon me?
Which gospel are you referencing?
Rested at 72. Rested at 72. So I'm merely, Mr. President, justifying my proposal why we should amend the clause to say that the child should be over the age of 12. I mean, I would prefer it to be 16, but we also know that you have some well-mature and reasoned 13 and 14-year-old. But I really do believe we should amend this and not leave it open to a child. Yes. And that's a good point Senator Knight has raised, that the age of consent is 16, and with good reason. So I believe that there is a plethora of reasons why we could look at this favorable minister and put a caveat in terms of a child, as well as legal disability. Legal disability, for me, I took a very limited view of the term and say intellectual disability, because we're going to have some children who, whether because the parents or the grandparents accept that there is some form of disability, will set up a trust just for that reason. And if they set up a trust for that reason, then we have to give them the benefit that they really don't fully understand right and wrong, or the full brunt of actions. And so for them to then be responsible for instigating or encouraging or concurring with an adult to breach the trust, I don't believe that they should be responsible. So I'm commending to you, Minister, for your review, and you could speak with the technical team. And I see Senator Braham is in full agreement with me, and I am so pleased, Senator Braham, that we're having across the aisle consensus. Yes. So I want to go quickly to clause 89, because I had no idea that I was speaking for 30 minutes. And clause 89. Thank you so much, Senator Knight. Clause 89. And I read this like 5 or 6 times, and I spoke to Senator Donna about it, because I said, something not so right with this. But this is what it says. It says that subject to the provisions of this Act, property vested in any person or on any trust by way of mortgage shall in the case of that person being sentenced to death or imprisonment by a court of competent jurisdiction remain in the trustee or mortgage, or survive to his co-trustee or descend to his representative as if he had not become a convict. So, clause 89, page 53. Clause 89.1. Yes, Mr. President. Now, I know that this was adopted lock, stock, and barrel from the Trustee Act, which we're repealing under this. But we also know the Trustee Act is kind of antiquated. And so I would want to believe, yes, I would want to believe that in drafting this new 2019 bill, that would kind of modernize all of it. But this provision betrays that belief. And so I have 2 recommendations. One, that the term person being sentenced to death be taken out completely, because we don't do that. I mean, Senator Knight, you can offer some guidance. Do we sentence people to death still?
Them, but we don't carry it out.
It's still done, but it's just not done. Okay, so I stand corrected. And the second concern, is that a trustee is a person who ought to be of the highest integrity and beyond reproach. And if in clause, let me see if I can remember. If in clause, where we do with the purpose trust, that's clause 5 or 10? In clause 10, sorry, no, it's not 10. Yes, in clause 16, 16 subsection 10, looking at purpose trust, we agree that the trustee can recommend that an enforcer who has a less, whose fiduciary responsibility is not as extensive as the trustee, that he be terminated because he is bankrupt. Bankrupt, you know, bearing in mind that we passed the Insolvency Act, which was supposed to take away the stigma of bankruptcy and insolvency. But we're saying, nonetheless, that the enforcer can be terminated, or removed rather, because he's bankrupt. Why not attribute that standard? In fact, a higher standard should be attributable to the trustee. So if a trustee is incarcerated or convicted, then he ought not to be a trustee anymore. And so I'm recommending that we look at that section, and I understand the content and I understand the intent. The intent, Mr. President, is that you don't want the trust to fail, particularly if you only have one trustee. But then you give that inherent power to the court, right? You have to, no, you give the power to the court to appoint a trustee, because we have already given the court power to appoint a trustee where the trustees fall below the minimum of 2. We have given the court the power to appoint a trustee when you don't have a trustee resident in Jamaica. So give the court the power to appoint the trustee where the trustee has been incarcerated or convicted. How will he function anyway? So I'm just putting that out for consideration. Oh, okay. And whereas I'm not so wedded to the other recommendations, this one I am, because I think that it runs contrary to the fiduciary responsibility and duty of the trustee and the desire that the trustee should be of the highest character. And I think this runs contrary to it. Yes, and you know, Senator Knight made a very good point that the issue of conviction, particularly where it touches on the issue of dishonesty and moral turpitude, then we have to consider those. And so I strongly recommend a revision of that provision, Mr. President. Now, Clause 92, and I'm winding down. Clause 92 has to do with the review period. Now, I know in the original bill we had 5 years, and it was then recommended by Senator Golden, sorry, Mr. Golden, MP. I do know he recommended it for 7 years. And I understand the reason. And the reason he recommended 7 years is that we really have not been complying with the legislative provisions that various pieces of legislation should be reviewed by a particular time. But two things. One, I don't believe that we should make perfection the enemy of the good. I believe that we should aim to review every single piece of legislation within the legislative stipulated time. Secondly, the issue of trust law is evolving so quickly. So when you look at Guernsey, and when you look at the BVI, and when you look at the Cayman Islands, you will find that their act is amended very regularly. You will notice when you look at it, you can see the different times that they have amended their legislation. And part of it is because they fully understand the importance of having a modern piece of legislation, but more so they understand that the area of trust law evolves so very quickly. And an international financial center cannot be static. So 7 years in my mind is really too long. And I, too, am recommending a review period of 3 years. Mr. President, those are my comments in terms of the statute. But I want to make a point, and it is that throughout the bill, there are several provisions for recourse to the court. And notwithstanding the work of former Minister Golden and the work of present Minister Chuck, both of whom must be commended, we still have a lot of need in the court system. And so when an investor is looking at a jurisdiction to invest or to set up his trust for this purpose, he's going to look at the court system and how quickly do we have matters resolved in court. If it's going to take 3 or 4 years, he will have to rethink. And so I am again making an appeal, Senator Braham, for more or retirement, and then you can't get a judgment. I'm making an appeal for more resources to be given to the court system. I know that in terms of the commercial division, and I really have to commend the commercial division. I mean, I have done work in that division, and I am always so pleased with the service, but I'm even more pleased with the timeline. I mean, it's very different from the other sections. I mean, you get a date quickly and things are disposed of with alacrity. So I want to recommend, therefore, that notwithstanding those positive improvements, that more, that more resources be provided to the court system to ensure that we can dispose of matter with greater alacrity. And Senator Braham, I am also encouraging the use of the Arbitration Act that we passed in this House, because it is going to save us time, it is going to save us resources, and that is somewhere that we can look. This bill, Mr. President, goes a far way in facilitating the dream of both administration of establishing an international financial center. But as we pass, and I do believe, and I hope I'm not being too presumptuous or overly positive, but as we pass this bill today, we know that the work is not yet finished. Various pieces of legislation are yet to be brought to this House. The Partnership Act, which was passed in this House, the regulations are still not done, so the act cannot come into effect. So we can't benefit from all the improvements that are contained in the Partnership Act. The International Business Companies Act, the Patents Law, those are still not tabled. So we still have a way to go to really establish and to give life and blood and energy to the establishment of the International Financial Center. But notwithstanding that, we support the bill, and we look forward to Jamaica really becoming the international financial center and attracting investment and the transfer of that investment to development for every single Jamaica as we create the Jamaica that works for all. Thank you, Mr. President.
Thank you, Senator. Sarah's mother.
Mr. President.
Senator Brown.
My reading around trust indicates, Mr. President, that it was developed by the courts largely in family and personal type situations. As time go along, my lord, Mr. President, as time my apologies, as time progressed, courts have applied trust principles to commercial matters. I recall particularly when there was a development by the judges in England concerning Rampala clause and so on, which allows persons who sell goods to deliver it to the purchaser and to retain the ownership until payment. That was created by the courts. And there have been substantial application by judge-made law and subsequently legislation to commercial transaction. But so it is against that background that I have been looking at the bill, because while I understand the value of the Trust Act for commerce and how it will benefit commerce, how it would benefit business in the country, the bill also affects trust that applies to personal relationships, to families and so on, just as well. And therefore, it seems to me that it is a formalization of the trust, but of the trust principle, which is very appropriate at all times, probably generally among businessmen and women. And you're doing your unit trusts and you're doing your pension funds and so forth, and those formalities are important. So I looked at it because individuals, when they're in their normal affairs, sometimes create trust without recognizing that it is called a trust. It effectively is a trust. And so my own concern is whether or not, when we create all of these persons, enforcer, protector, and so on, whether it would make a simple trust for the average man, whether he knows he's creating it or not, onerous in terms of expenses. And I was, in seeking clarification, I was advised, Mr. President, that it won't affect them. And it may well be so, that it will not necessarily affect them, make the trust principles become too onerous for application for the simple individual. Indeed, you'll note that the definition of trust, or the creation, how to create it, is very expansive, includes, it can be oral, it can be by conduct, and so on, which is beneficial to the regular persons, Mr. President. But of course, if you look later in the Act, it deals with the question of property, real property. And I had to look at that very carefully, because in that type of situation, we now have it expressly provided that you must have a trust relating to real property by instrument in writing. That's a good thing and could be a bad thing. It's a good thing because property is such an emotional subject in Jamaica, Mr. President, and you want to ensure it is so. But prior to this, of course, you still have the statute of fraud, and it's a very nuanced approach on the statute of fraud. You don't need to go out of your way and say, well, this is a trust, so long as there's some evidence in writing if it deals with property. On balance, it may well not be too much of a problem, but I wondered whether that was an issue. And on balance, I've accepted that if you are dealing with real property, you should directly create it, as again simply declare a trust orally, and then sometime later you may be writing a letter to somebody overseas, and in that letter, say you created a trust 6 months ago or in 2005, and then that's an oral trust in relation to a piece of land in Walton Park Road, which has been given to a trustee in favor of some beneficiaries in the children of some community, etc. But you did it orally, that would not have been adequate under the old law. But if subsequently you should write a letter to a friend and say, oh, you remember that that piece of land there that I'm holding for the children of Walton Park Road, then that may well be evidence of the trust in writing. It's a slight nuanced situation. I don't want to bore you with it, but it's not as onerous as saying that from the get-go you have to create it by an instrument. But I have been persuaded that it is probably more beneficial that if you intend to create a trust, you should go to a lawyer or get a form and fill it out and create it. The second thing that concerned me is that if you create a modern trust act, whether or not you would have affected the evolutionary nature of the trust. In other words, the court's power to fashion trusts in different situations and call it different names over time. And indeed, you would have seen that under the same section 10 of clause 10, it says a trust of real property situated in Jamaica may be created only by an instrument in writing. And then it says at 4, I'm sorry, I thought there's a section that sets out expressly that says that when it comes to trust dealing with property, then yes, it says here, nothing in subsection 3, and then B says, affects the creation or operation of a resulting trust, an implied trust or constructed trust. But my initial concern was that it was only limited to property, to real property, and that the court is fashioning trusts for situations apart from property all the time. And so I wondered whether it was a limitation factor if we were tying the court's hands. I would not want this bill to tie the court's hands, to fashion trusts and so on, to suit situations as they develop in the next 10 years. And that, of course, can be cured by the review of the Act regularly. But my experience with reviews over the years has not been very, does not happen regularly. But I don't want the court's power. Indeed, I just read recently where they come up with a new trust with another name. I mean, I won't bore you with it today. But all I'm saying, I'm sorry? All I'm saying But when it was pointed out to me, though, that when you look at section 10.1...
Senator Braham, I'm pleased that you direct your comments to me. Thank you so much.
Thank you. Thank you, President. Thank you, President. That the definition of, it's set out in 10.1, it says, subject to subsection 2, 3, 4, and 5, a trust may be created by an oral declaration, by an instrument in writing, by conduct, or in any other manner whatsoever. And so, having looked back at it, it does appear that it is wide enough for a judge to say that in a particular situation he's going to declare a constructive trust, or he's going to declare an implied trust, or a resulting trust, or a trust by any other name, I hope. And I trust that it is very important that the bill does not prevent that from happening. And so if you want to look at it to ensure that I'm correct, I'll be grateful, because to me, when you have a matter in court, if you're a commercial practitioner or you are a civil litigator, your client comes to you with a problem, it cannot be remedied by contract. It cannot be remedied by tort. It cannot be remedied by statute. You start to wonder, now, is there anything in equity? Can there be trust that we could use to fashion something? How can we create it? Even in the context of the Registration of Titles Act. So that you understand why I am concerned that we wish to freeze in time the creation of trust. That is a point that the court ought not to be given carte blanche. But the fact is, though, that the courts of equity have developed principles over the years based upon which they fashion it, and also based on changing the situation, they have created other circumstances. So, for example, in cases in the 1990s, where husband and wives had to deal with banks and so on, they came up with a concept to, depending on whether the wife received advice, whether or not the husband was used as an agent for the bank in advising the wife, they used that purpose in a Barclays Bank case to create a trust for the protection of the wife. So I understand what you mean, Senator Knight, that it cannot be too open-ended, but having regard to the fact how it has developed over centuries, I would prefer to ensure that they do have that leeway. That leeway. And it appears that on the wide definition of trust and the formation in section 10, that possibility still remains. The third issue, and I won't be long, the third issue, and I mean, I am coming from the point of view, not from so much the commercial aspect. Those persons usually have a plethora of persons to defend their interests. And indeed, this is very good insofar as making Jamaica a place for international business, to give us certain facilities, certain like as other countries, our islands, Cayman, Guernsey, and so forth, and that's very good. But at the same time, you have regular people who are interfacing with trust principles every day, even though they don't know that it is called trust principles. And oftentimes, that's what the lawyers have to use to rescue a young client from a commercial bank or from some other agency, a money lender. And there's nothing else. And that's why it is so valuable. The third point that concerned me, Mr. President, was to ensure, when you read the bill, you will see that the desire to be retrospective is very, very high. It is. And I think that if I look, Mr. President, I think at clause 3, it says, subject to section 96, and except where provisions is made to the contrary, this act applies to trusts created before or after the commencement of this act. this act applies to both a Jamaica trust and a foreign trust over which the court has jurisdiction under Section 6. So on the face of it, Section 61B, on the face of it, it would appear that the desire for this bill to cover previous trust creation before the bill and after. But it says so, effectively says so. But what happens now, as we speak, there are persons in the RM Court and the Supreme Court, including myself, who are processing matters through the court concerning or trying to persuade the court to declare the existence of a trust in particular situation. And this is not situations where you have a trust deed or anything like that. You may just have a simple letter, whether it's a constructive trust and so forth. So on the face of it, this bill would apply. There is a general principle in law in relation to legislation that it would not affect court action already. That is a presumption. That is a rebuttable presumption that it would not affect court actions already in train. And if you look at Section 95, it says, Clause 95 says, nothing in this act affects the functions under any provisions of any law of a guardian or an attorney. B, subject to subsection 6, so Section 6, validates an otherwise invalid disposition or property to a trust. C, affects the validity of anything done in relation to a trust before the date of commencement of this act. D, affects the validity of a trust arising from a document or disposition executed or taking effect before the date of the commencement of this trust. Now, from those sub-clauses, it may well be that you could ask a court to interpret that the bill did not intend to affect court actions already in train relating to trusts in courts, as I'm saying. It appears that you could... Clause 3 says, nothing in this act derogates from the powers of the court which exist independently of this act to set aside, vary, or reduce any transfer or other disposition of property, testamentary or otherwise, in respect of trusts, trustees, or other properties, to make an order relating to matrimonial proceedings, to make an order relating to the avoidance of fraud and creditors. Nothing in this act affects a personal representative acting as such. You still have to interpret it. It may well be useful to say, make it very clear that rights that have been accrued or actions in train that the bill would not affect. And I think that I'll be more comfortable if it makes it clear and I don't have to spend 2 hours arguing it. Anything done before the date of commencement of this act or in the process of being done on that date under the Trustee Act, which could be done under this act, shall have effect as if done or, as the case may be continued under this act. But then the thing about it, it says under the Trustee Act, the previous Trustees Act, and that I regret to say that there was a point in time that we're dealing with trust principles without realizing that there was a Trustee Act. Because the principle had long sort of outdone the Trustee Act. So I'm not sure that that would take it any further. I would be more comfortable if we make it abundantly clear that persons who already have commenced their actions and trust our reply that this act would not affect their rights already accrued. It is the norm and yes. And a court may well interpret it that way, but interpreters do things differently all the time. So I am satisfied, Mr. President, that generally it does not affect the regular personal relations, the simple trusts, the family trusts that are created. People saying to people, you know that the property in Haddo belongs to you, and so on. Well, all of those places, they're not very valuable in price though. But the point I'm saying is, these are the personal trusts. These are the family trusts that we have to look carefully to ensure that we do not do anything to inhibit, even while we promote the commercial trust, and the validity of which is very important. But of course, we need a two-horse race as against one. I think that the draft may have achieved the purpose, and therefore I will support the bill generally. Thank you very much, Mr. President.
Thank you, Senator Bram. Senator Brown.
Thank you, Mr. President. Mr. President, as Senator Fraser Binns pointed out, the opposition supports the bill in general and a lot of the specifics as well. As Senator Bram just pointed out, this is replacing the 1897 legislation, the Trustee Act. Huh? Yeah, that no one president born after that. He born after that. But this 1897 piece of legislation, in a sense, is outdated. And that brings a certain responsibility on the government now, that we should embark on a public education program so people understand the value of a trust. That a trust is not only for the big people in the society, but it can apply to the little man in the farthest corner of our district who could benefit from this. There is a way in which we don't bring our people into the benefits of the legislations we pass. And one of the best way to do this is the public education program. For example, I've seen cases running all the way up to the Privy Council, Senator Knight, as to what is a trust. You would well recall that there was a debate as to whether the National Housing Trust, because its name a trust, is a trust. It was ruled it was not a trust. Similarly, we have the National Education Trust. And I'm not sure whether it is a trust in the sense of a trust, or it is just an organization for which there should be some trust given in it, but not a trust in the commercial and practical sense of this law. So it's important so people know the difference. And Senator Brown, I think you said a trust have different names. There are many foundations that exist now, which are really trusts in the real sense. So it's important that we make that distinction so that people can understand and appreciate how they can benefit. I was tempted, Senator Samula, to say, seeing in this bill about the third party, whether it meant the third party relations, that the National Education Trust seems to be getting involved with through CMU, but I figure it's not what is intended, because there seems to have been too many third party activity here. But I think the third party on page 6, the third party on page 6 is not intended for that. But we know that there have been some apparently nefarious third party dealing from an organization that calls themselves trusts. Right? Mr. President, Mr. President, I just want to point out a few issues in the definition clause. But before that, I want to look at 4.1 and page 7, whether the intention here, subject to the provision of this act, a trust exists if a person, a trustee, holds or invests or has invested in him, etc., etc. And Minister, at 19 and 20 we're pushing for more than one trustee. Maybe the formulation here ought to be one or more persons, so that it's clear that we're not just limiting trustee to one person, but one or more. And just the word in here may just could give that issue some difficulty. So just ask your people to look to see if it makes sense. The ones I want to bring your attention to is at page 3, Mr. President. It speaks to excluded bodies. Excluded body. And it puts the trade union political party as part of the excluded body. I'm concerned about it today that it lumps the trade union with a set of undesirable. In 1919, the law was changed to recognize trade unions. Before that, trade unions were seen as criminal enterprise, engaged in unlawful act. And so now we see the trade unions and political parties being lumped in a section with bodies that promote purposes that are unlawful, prejudicial to public order or public safety, in support of terrorism or terrorist activities, whether those activities occur in Jamaica or outside of Jamaica, or for the benefit of an organization being a member which is unlawful. And I'm told that similar wording is in the Charities Bill. But in the year when Jamaica celebrates 100th anniversary, the 100th anniversary of the Trade Union Act, I would like the draftsmen not to associate the trade unions.
Draft persons, I'm sure you mean.
I will take your word in drafts persons, male and female. And I don't even think any male is there now. But I hope they're not offended. There's one iron. What we're saying is that can we find a way, notwithstanding that it's in the Charities Act, because that will have slipped me. 100 years after when the Prime Minister is in Geneva, bigging up trade unions and so forth. 100 years after the government is celebrating the establishment of the Trade Union Act. I would wish that the trade unions not be associated with these organizations and persons. Whichever way we must draft it, take the trade unions out of it. And I'm not comforted by the fact that it may be in a previous bill. That bill ought to be amended and changed it too. Right? But, so we can find a way, Minister, to separate the trade unions from these criminals and terroristic groupings.
Let East stand alone.
Yes, there are ways to do it. But take us out of that. Take us out of that. Take Senator Gale and I and the people we represent in this country out of that group in there. Right? So that's one. And there are ways we can propose when we come to committee to address that. But on behalf of the trade union movement of Jamaica, on behalf of the trade union movement of the region and of the world, we ask not to associate us with these type of organizations. The perception, the optics of it is our concern. And we raise that. The second one I wish to raise under the definition of clause, and hope we can find accommodation also on this, is the definition of personal relationship on page 5. Personal relationship on page 5. You said the bottom of page 5? No pun intended. Mr. President, personal relationship is defined as follows. It includes every form of relationship by blood, adoption, marriage, or cohabitation regardless of whether the law of any jurisdiction recognizes the validity, legitimacy, or existence of the relationship. What is this introducing in our country? Not in my cabinet, said a former Prime Minister. What is this introducing? Mr. President, all of us, at the bottom of page 5, personal relationship. Mr. President, obviously we copied this from somewhere else. But in this chamber, every single one of us swear an oath to uphold the Constitution of Jamaica. And if we're going to honor that oath, this clause can't stand. This clause passed 63 elsewhere. It must not pass the 21 of us in this chamber. Let us be clear. Let us be clear what it's saying. Personal relationship includes every relationship involving cohabitation. So, Steve and John can cohabitate, and that is a relationship in our country where our Constitution recognizes marriage by a male and a female.
So how this pass policy?
How can this? How can this? I don't care where it come from. We're not going through the back door here. We're not going through the back door here. So let us be clear, Mr. President. Let us be clear. The Constitution of Jamaica. The Constitution of Jamaica lays down certain things. We copy something from other people with their arrogance. They say they don't really care what the Jamaica Constitution says. A trust must be dealt with that way. But we must care about what our Constitution says. In every bill that we deal with spouse, we say a spouse is defined by a male and female. But in this bill, it leaves cohabitation of male and male, female and female. It could lead to an acknowledgement of something our Constitution turn against. The same-sex marriage being accorded recognition by the law passed by this Parliament. And consider this, Mr. President. A couple of years ago, in Ligini, where I born and grew, a certain institution raised on their flagpole what is called a pride flag. A pride flag. Flag supporting the homosexual community. The Attorney General of Jamaica tweeted against the pride flag. Tweeted against the pride flag. How can the Attorney General sit in the cabinet and allow this clause to come out and we don't get a tweet? How can this go to legislation committee and come out? How can this pass the Parliament in which the Attorney General sits without being noticed that this seems to be unconstitutional? So, Mr. President, I have a big concern about this personal relationship and what we are about to let in. So I can't support this definition in this bill. I have said to my side, if I alone have to divide, I have to divide on this one. So that I'm asking the government to consider, reconsider this definition in light of the Constitution, in the light of which we approach. Then also, Mr. President, it goes on and says, and a personal relationship also exists between two persons if a personal relationship exists between each of them and a third person. What the hell does this mean, President? What does it mean? When I sent it to a lawyer this morning, Senator Knight, and it wasn't you, the lawyer said back to me and said, polygamous relationship? So that's what it stir up in people. I hear threesomes, but I don't know if that's what is intended here. It could be polygamy. So we're adapting something. I am sure we cut and paste this, that this is not an original thing. So, are we promoting polygamy? I don't know, because nobody has explained this to us. But what does it mean? And a personal relationship also exists between two persons. If a personal relationship exists between each of them and a third person. And part of personal relationship include cohabitation. And if you look at the definition of cohabitation, you see it includes sexual relations. So I'd urge the government, yes, it has passed the 63. Yes, the minister says this is a technical bill. Yes. This is a part of extra technical. Yes. They didn't pick it up. But that is why, Senator Knight, we are the review chamber. And we look to see these things. So I would take time to read these bills, not just to bang the desk. And this is fundamentally something I can't support. I urge the minister to look at it. Maybe we shouldn't go through all the stages today, so we get some policy direction. Because let me tell you where it's going. This bill comes to us. This bill comes to us through the Prime Minister. So what would be being said, Senator Morgan and Senator Samuda, is that there's a fundamental policy shift. A fundamental policy shift by the government to embracing cohabitation by men. I am proclaiming that that's now your policy as outlined by this bill. Right? So it cannot be that the Prime Minister name is associated with this bill. So I urge, don't know if he's back from Geneva, that's why Morgan was appointed, but pause on this bill. Let us make sure we get a definition that fits our constitution. It cannot be that the Prime Minister, it cannot be in the Prime Minister's name. Hold on. It cannot be in the Prime Minister's name that we're promoting same-sex. It can't be in the Prime Minister's name that same-sex marriage is introduced. This is the Prime Minister's bill. This is the Prime Minister's bill. And the Prime Minister I know, is not into that. The Prime Minister I know is not into that. The Prime Minister I know is not into that. And I therefore urge the rest of those on that side not to join it. Not to join it. Eh? Prime Minister not into polygamy. It runs against the Constitution, runs against the Constitution. It runs against a policy directive. The Prime Minister once said he would have referendum on buggery, ganja, and CCJ. Well, there's no referendum on CCJ. There's no referendum on ganja. And I have not heard of any referendum on buggery. So I can't see how we would get to the buggery thing in this legislation and to sanction it by this definition. That's what happened when we cut and paste from other places without regard for the sensitivities of Jamaica. If I was opportunistic, Mr. President, you know what I'll be saying? Boy, this government into Wobia, this government into abortion, and now this government into same-sex. But I'm not going to say it because I'm not an opportunist. I just said the Prime Minister don't believe in it. So I know that. I know that. And I know that Attorney General. No, I'm not going to repeat myself. I'll repeat what I'm saying. I know the Attorney General don't believe in it. I don't know if she see it, miss it. Because when the flag went up in Ligony, she was quick to tweet. Tweet faster than Trump. So much so that Trump has heard her and said no more flying up that flag. You never know if I did. I thought they were rude to have come. It no matter. What I want you to do is support me that this class can't stand. May it please you, Mr. President. May it please you.
Thank you, Senator Brown.
Mr. President, the time being 1:20, may the standing orders be suspended to allow the sitting to continue beyond 1:30 to finish the business of the day.
The question is that the time be extended to beyond 1:20 to finish the business of the day. Those in favor? Those against? The ayes have it. Could the House kindly indulge us for a minute while the leader gets, Minister gets a clarification?
All right. It's very brief. Very, very, very brief.
Senator Knight.
Thank you, President. President, I had not intended, quite frankly, to make any intervention, but Senator Lambert Brown raised an issue which is occupying my mind. And it is, if it is that having regard to our constitutional provisions, a difficulty would arise, whether or not in those circumstances an appropriate person could seek to have the trust varied, and whether a court would vary based on a finding of unconstitutionality. So a real issue has arisen, and I believe that some time should be spent to iron that out if it can't be done immediately, because the bill specifically preserves the right of a court to vary a trust. Then that has slightly wider implication. Does it, for example, affect the Family Property Spousal Rights Bill Act? Does it have implications for that? Because in certain situations, a trust can result from how property is shared, how property is held. So I think that this calls for some deeper contemplation, because it can disrupt, affect in several ways a relationship, and could cause the kind of difficulty where if the Parliament is legislating, I'm kind of thinking as I speak, if the Parliament is legislating something that is unconstitutional, there is a difficulty. And the very least that has to happen is that prior to, if it's passed, prior to its coming into being, when the Attorney General is to certify to the Governor General that the bill is constitutional and therefore can become an act of Parliament, that in the interim some consideration be given as to, some further study be undertaken. Question in my mind again is, if the bill is passed and then the Attorney General at a later stage, before it goes to the Governor General, says, no, I can't send it to the Governor General because it's unconstitutional, what happens? Because it has been passed here. It would have to come back here through all its stages, downstairs and the Senate. So maybe it ought to be looked at further, because a real issue has been raised. I know courts have some peculiar ways of varying these trusts. I remember as a student studying equity and trust, came across a case where the beneficiary of the trust lived in England, had to live in England to get the benefits of the trust, but wanted to move to the Isle of Man, where the tax regimes were less onerous. And the matter went to the appellate court, where Lord Denning then was. And Lord Denning refused to vary the trust. And he refused to vary the trust. And he said this, and those words have lived with me from the time I read them and guided me for over 46 years. And the words he used were, in refusing the variation, there are some things in life more important than money. One of these is to live in this, our England, the envy of less fortunate countries. Lived with me. And the operative part, mostly, for me, is there are some things in life more important than money. And here, somewhere along the line, this trust is going to involve the whole concept of money. And I think we have, as a parliament, to decide whether the law as framed to give fluidity to the interpretation as who it covers, if it is not more important to ensure that the constitution of our country is not breached than it is to provide for a few. So I don't know if the engagement of the leader of government business is on that aspect. But if it is not, then I ask Senator Brown to be kind enough when she comes to tell her the sentiments expressed in this regard.
Mr. President, might I ask that we have a brief 5-minute suspension of the sitting to just allow for some conferral to take place?
Your question is put that we should have a 5-minute suspension to look at the issues being raised, and those in favor? Those against? The ayes have it.
I got involved with the peace management initiatives. It was living in this community, your Mountain View. Community was